After 6 years and 3 months exactly since her body was found in a sugarcane plantation in Lugazi in Bwiko district, the High Court in Mukono this week commenced Desire Mirembe's murder trial. Mirembe, then aged 19 years and a medical student at Makerere University, was allegedly murdered by a boyfriend and fellow medical student on July 6, 2015. The suspect, media reports indicated at the time, confessed to the act, was charged at the Jinja Magistrates Court with murder and remanded. 16 months later, on November 24, 2016, the suspect was granted bail. The deceased father is Emmanuel Musoke, the former district chairperson for Kalungu district. But not even his political clout could help in expediting the trial. Police sources say investigations were completed in 2 weeks by August 2015 and the file submitted to the Director of Public Prosecution, or DPP. At the behest of the former principal judge, Yorokamba Mwine, the case file was transferred from Jinja to the Mukono circuit, in whose jurisdiction the DPP contended that the incident happened. In 2017, the Mukono High Court indicated that it does not have money to start hearing the case. 4 years later, in May this year, the same court had an application in which the suspect sought the return of his passport to allow him to travel to the United States for postgraduate studies. There was drama after his lawyer told court that his client could not even make it to the court that day, only to be found in his car parked outside the premises. Mirembe's murder case is among the handful that get constant media coverage, including the August 2019 gruesome murder of Maria Nagirinya and her driver Ronald Kitayimbwa. 2 years later, police say investigations were completed and the file forwarded to the DPP, but the case is yet to be cause-listed. The suspects have been on remand for 2 years. But there are hundreds and possibly thousands of such homicide cases that are not reported in the mainstream media. Thousands of suspects are languishing in prisons on remand for more than the 180 days in the proposed bail reforms for various reasons, including sluggish police investigations, delayed cause listing, or as a result of human resource constraints plaguing the judiciary and the DPP's office. In several other instances, police spends long spells investigating or evidence is bungled up during investigations. Averagely, according to police's crime reports for the last 6 years, 4,000 homicide cases are recorded annually. In 2020, out of the 4,460 homicide cases, including death by shooting, mob action, poisoning, aggravated domestic violence, fire outbreaks or other causes not specified, at least 2,351 cases were investigated, of which only 1,269 were taken to court, out of which 1,983 files were forwarded to the DPP, resulting in 34 convictions, 1 acquittal, 5 were dismissed, and 1,229 were still pending in court. An analysis of police's crime reports for the last 5 years shows a variance between cases recorded generally, especially the capital offences, and the case files subsequently forwarded to the DPP for possible prosecution.
Sometimes it's a matter of perception. What people see as cases that were reported and they are not disposed of, sometimes it's not our own making. We have had cases which we have investigated, murder in nature, assembled what we believe is really evidence, discussed it with the Office of the Director of Public Prosecution. Our evidence agreed by the ODPP as sufficient evidence to warrant prosecution. They accused the people are committed to the High Court, but a year, 2 or 3 or 4 years elapse when our cases have not been cause-listed.
Charles Twine, the spokesperson of Police's Criminal Investigations Directorate, says there are good reasons for the variance, mostly institutional and individual to the cases.
So the moment the cases take long, it even has another multiplier effect. That some people will say, omwavu tasinga musango. So there is no need as to why you should go to police and report the case. After all, the other case has taken forever. The case of Nagirinya, we did exceptionally very good. And we are ready to commence hearing. But there is where we don't reach. There are some other friends and stakeholders whom we don't supervise.
When we peruse a case file, we can decide to sanction charges that have been preferred by the police. And when we sanction charges, then that matter proceeds to the court for hearing by the court. We can also decide to send a case file back to the police for further inquiry. This is where we peruse a case file and we find that investigations are incomplete and there are areas that we feel that the police should investigate further into. So we send those files back to the police for further inquiry, specifying which areas they should investigate. When we peruse a case file and find that the evidence is not sufficient for the matter to go to court and there are no areas for further inquiry, we close that case file and that marks the end of that matter.
In 2017, out of the 252,065 cases registered, only 66,626 cases were taken to court, out of which 18,961 cases secured convictions, 1,419 cases acquitted, and 9,613 cases dismissed, while 36,633 cases were still pending in court. That leaves a balance of 185,439 still under inquiry or not proceeded with. In 2018, crime dropped by 5.2%, wherein 238,746 cases were registered, down from 252,065 cases in 2017. The cases taken to court were 73,035, of which 22,263 cases secured convictions, 1,248 cases were acquitted, while 90,763 cases were still under inquiry by the end of the year and carried forward into 2019. The balance is 51,437 cases still under inquiry or not proceeded with, but police doesn't specify. In 2019, crime decreased further by 9.9%, with 215,224 cases reported, out of which 74,810 cases taken to court. In 2020, when the country imposed the first lockdown to impose the spread of COVID-19, crime declined further by 8.9%, or 195,931 cases registered, out of which 56,651 cases were taken to court, out of which 15,657 cases secured convictions, 359 cases were acquitted, and 3,754 cases were dismissed, while 36,881 cases were still pending in court. That leaves 139,280 cases still under inquiry or not proceeded with.
We also have the issue of cases that don't have an outright physical evidence, especially in violent crimes. You go to the scene of crime, there is virtually no clear evidence. As in, the only thing you could use is science and technology. For us, through every scene of crime we visit, we get some scientific evidence, sometimes in form of saliva, sometimes in form of hair, sometimes in form of a cloth, sometimes in form of any fluid. And we have very well trained scenes of crimes officers and forensic investigators. They swab the place and get the DNA samples. But where do you compare them from? At least of recent, we are trying to get some information from NIRA regarding the fingerprints. But DNA, we don't have a DNA bank.
The reasons for not proceeding with the cases are many and vary. The police reports for the last 5 years show that 50% of the crimes, especially defilement, theft, rape, burglaries and murders, are registered in rural areas. The defilement case of Sarah Babidie, an 11-year-old girl, is yet another example of a case that could be buried in the footnotes of the police crime report for 2022. Babidie, a resident in Nachibano village in Kimenyende sub-county, Nachifoma county in the deeper resource of Mokono district, lodged a defilement complaint of her daughter by an 18-year-old employee at the farm, but police is yet to commence any probe.
I went to police and reported the crime and explained everything. Then they asked me for 70,000 shillings to acquire a PF3A form. They gave me some other forms to photocopy. Then they asked me to contact the child's father for money if I didn't have it. But I told them we separated long time ago. They said I should at least find some small money for them to start with.
She said after this nasty experience, she focused on treating and rehabilitating her daughter.
After failing to raise the money for police to investigate my case, I gave up on the case and borrowed medicine to treat my daughter.
The farm manager gave her 20,000 shillings to help in the treatment of the daughter while the suspect fled. This is what we unraveled at the police post that takes the jurisdiction where this defilement took place. A notice is glued to the door detailing that a police form is free. An assault PF3 form costs 20,000 shillings, a defilement PF3A form costs 30,000 shillings, a rape PF3A form goes for 30,000 shillings, while both the PFA2A and PF24A forms are free of charge. This means that a complainant who cannot afford the money for the forms and sometimes transport facilitation for the officers doesn't get assistance. Stories are abound of especially burglary and housebreaking victims of calling the police landlines for assistance only to be told to send mobile money to fuel patrol cars. It is said defilement cases are complicated by the delayed cause listing by the judiciary or other factors.
Somebody who was defied in 2012 and he was probably 17 years, he is now somebody's wife, is somebody's mother, is somebody's manager, is somebody's supervisor. And now bringing such person in the dock to testify as a witness, somebody's manager, you may say no. And that inevitably now puts our work into a predicament. Our record shows that yes, we registered this case, but the witness is not ready to proceed. So at the end of it all, the disposal of cases vis-a-vis what was reported creates that virus.
Cases are also impeded by the syndicated corruption in the criminal justice system. Parliament is due to start debate on President Museveni's proposed legal reforms on the bail system intended to tighten the hands of judicial officers and police in exercising their discretion to grant or deny bail and bond respectively. The reforms already rubber-stamped by Cabinet entail amendment of Article 236B of the Constitution to provide that a person accused of committing an offence triable by both the High Court and subordinate courts shall not be granted bail until after 180 days or trial commencement or when the DPP discontinues proceedings, whichever is earlier. The proposal also seeks to amend Article 23(4)B and Section 25 of the Police Act, both of which require a suspect to be released on police bond if not charged in court within 48 hours. The changes set out to qualify the period as 48 business hours. The proposals have elicited flak from all quarters, including the judiciary, DPP, Uganda Law Society, law scholars and the public. Law scholars have argued that the bail reform proposals violate, among others, charters, the Universal Declaration of Human Rights, and the African Union Commission on Human Rights and People's Rights. With the largely pliant August House, fears abound that the contentious proposals could be passed and a new law that bears a semblance to the draconian laws on detention without trial during the Obote I regime could be reintroduced. The 1995 Constitution prescribes the right for bail application, which can be granted or denied by the court. This matter has been a pet subject for President Museveni for a while, since the aftermath of the novel opposition protests dubbed Walk to Work in 2011, but his calls reached a crescendo recently. Under the law, the capital offences for which amendments to the bail law is sought include murder, rape, kidnappings with intent to murder, aggravated defilement, armed robbery, treason, and terrorism. Annually, police records about 40,000 of such cases. Article 23(4) of the Uganda Constitution reads, "A person arrested or detained shall, if not earlier released, be brought to court as soon as possible, but in any case not later than 48 hours from the time of his or her arrest." A majority of suspects are detained in police stations for longer than 48 hours as a result of a variety of factors, including lack of control over the suspect, lack of ample transportation, and backlog at DPPs. Police themselves are known for selling police bond, which is supposed to be free. Even cases committed for trial take longer.
Example of one court which I have offhand, of Fort Portal High Court Circuit. Fort Portal High Court Circuit has around close to 7 districts, because you have Kasese, you have Kabalole, you have Nyangabo, you have Kamwenge, you have Chegegwa, you have Ntoroko, Bondobujo. So those are the courts which compose that circuit. Now, they have close to 800 criminal cases which are committed at High Court. 800 criminal cases committed at High Court. If you go by a session of 50 cases, if you divide by a session, that is around, you have around 16 sessions to handle those cases. That means you need around 16 judges to sit at a go to handle those cases and finish them. We have in total, currently, we have 58 High Court judges who are supposed to attend to those committed High Court cases. We have talked of Fort Portal alone. Now, when you go around the whole country and look at the number of committed cases, compare them with the judges, it becomes quite impossible for them to attend to these cases in time.
In his speech delivered at the opening of the new law year earlier in February, the Chief Justice, Owing, decried the inadequate funding and staffing of the judiciary, which inevitably results into escalating case backlog on all court levels. The backlog level as of December 31st, 2020 stood at 48,696 in the court system, from the Supreme Court to the lowest court. Judiciary spokesperson James Kademani says funding remains the biggest constraint.
In a matter, for example, in a matter for the High Court, which is a capital offence, is committed, and the person has already been committed to High Court by the lower court, where he keeps attending after the charging. When that person is committed to High Court, because we don't have sufficient resources in terms of human resource and financial, we cannot try that person immediately after that committal. So that leads to handling those cases in a session manner. A session manner means we get 50 cases at a go and give them to a judge who spends 30 to 45 days handling those cases. Now, because of the limited resources and financial resources and human resources, the number of sessions that can be held in a year are limited.
He said delay of gender-based violence capital offences like rape and defilement cases sometimes lead to their collapse.
Once a case takes long, the witnesses who would be eager to testify, they lose morale. They lose morale because of different things. Some of them relocate from where they were staying. By the time you want to hear the case, they have gone far. You can't get them. Some have gone on and forgotten about the issue. If it's a girl who was defied when she was 14, now coming 5 years, you want her to come and testify. She's 20, 19. She has got married. She's moving on. She doesn't want to hear that past experience.
Other times, cases that are poorly investigated and lack cogent evidence cannot be sustained by the prosecution. This, the DPP spokesperson, Jacqueline Okui, said because they don't frequently work with police in investigations as it should be.
It's very important that most of the cases, a majority of the cases, if not all the cases, are prosecution-led. That we get the case files at the earliest opportunity, or the prosecution is involved at the earliest opportunity in the investigation of criminal cases.
The DPP's office is also constrained by funding and human resource shortage.
We have had instances where, for instance, our budget has been cut. Our budget has been cut, and yet the budgets of our partners, for instance, the judiciary and the police, have been enhanced, and yet we are part of the criminal justice chain. So one wonders how the prosecution office is expected to cope with the other justice actors. We also have a staffing problem. The Office of the Director of Public Prosecutions is grossly understaffed. We are currently operating at 40% prosecutors. So you find that in certain magisterial areas, there's a resident state attorney, and that resident state attorney is in charge of 3 courts, implying that he or she cannot be in all.
Over the next 45 days, starting tomorrow, the DPP and the judiciary plan to dispose of a backlog of 700 sexual gender-based violence cases, some capital offences, with the oldest case dating back to 2015. During a similar session in 2019, the oldest case stretched back to 2012.
We care. This is why we have initiatives, for instance, like the plea bargain initiative, which is intended to fast-track cases, criminal cases. Plea bargaining is where we make an offer of a sentence to suspects who consider themselves guilty. That is lesser sentences in respect of those cases. And in those cases, the witnesses don't have to come and testify. That is why they are fast-tracked.
At the end of the day, you realize that the best way to tackle all this is by availing the human resource and financial, so that everything is expedited, and if the person has committed the crime, is convicted. If he has not, he's exonerated at another time and goes on with his life.
We don't legitimize evils and weevils. We don't legitimize it at all. But what I can accept is that there are some errant police officers that can individually disregard the processes and the stand of Uganda police and do unethical things. So a murderer who has not joined police, once he joins police, it takes time to move that spirit from him. So we need to address the moral issue of the society.
There have also been incidents where suspects have gone missing after being granted bail, which results into delayed justice. For instance, according to the judiciary, 120,000 persons jumped court bail, 40,000 under the High Court, and 80,000 under the Chief Magistrate's Court over the last 10 years. According to police records in 2021 alone, 4,300 suspects jumped bail, which requires that one reports at least 3 times they are required to report. The bail reforms, once approved, also have implications for the justice, law and sector, including having to increase budgets for, among others, boost staffing and accommodating suspects in the already congested prisons or police jails. In this financial year, 2021-2022, police budget, crime investigations, forensics, and canine services were allocated a paltry 48.9 billion shillings to investigate all criminal cases, while purchase of specialized machinery and equipment was allocated 123 billion shillings. But in the grand scheme of things, bail is just among other issues plaguing the criminal justice system. There are fears amongst observers that the executive's clamour for bail amendments could as well be a red herring for the system to target the opposition.